The time is 4:39 p.m. 16. January 16, 2018. Time is 4:39 p.m. and we are in the Mark Ridley Thomas Constituent Service Center. Ms. Armstrong, please call the roll.
Commissioner Baines?
Present.
Commissioner Willis?
Present.
Commissioner Anderson?
Present.
Commissioner Rosa?
Present.
Commissioner Stern?
Present.
We have quorum.
Thank you. Excuse me. Now I'd like to go over some general instructions. Please note that this meeting is being recorded. Therefore, we ask that you speak close to the microphone and that you speak one at a time. Please state your name before you speak. Audio for this meeting will be available within 2 business days online through the planning website by selecting commissions and hearings. We will be following the agenda order. Agendas are located in the rear of the room along with speaker cards for each item. If you wish to speak before the commission, please fill out a speaker card and turn it into Jason. Please note that the general public comment period is for any item that is not on the agenda today, that is within the jurisdiction of this commission. Please turn off your cell phones or put them on vibrate so as to not disturb the proceedings. Disruptions will not be tolerated. If you interrupt or disrupt the proceedings, you will receive 1 warning. If you continue the disruptive behavior, you will be asked to leave the meeting. 1 note about item number 2, if you represent a certified neighborhood council and you have a written resolution or community impact statement, please submit it at this time to Jason, as we will be calling that item shortly. Yes.
Hello. My name is Dr. Amy Carnes. I am the USC Community Interest Representative on the North Area Neighborhood Development Council, NANDEC. Our borders are roughly western to the 110, south of the 10 to MLK. We have multiple drilling sites in our area. It is a great concern to our community, and I'm here to speak against the appeal that is on the agenda later on. Is this the right moment to do that?
Yes.
Okay. So I'm here as a representative of the neighborhood council, as a community member, as a mother, and as someone who generally cares about the health and well-being of other humans. I remember when we bought our house several years ago, we had to go through all of the disclosures, and one of the I was expecting certain things, like you have to disclose if you're near fault lines because we live in California and that's part of our reality. I was not expecting to have to hear about oil drilling so close to our home, and not just 1 site, but 2 within a couple, less than 2,000 feet. I had a 4-month-old baby at the time, and now I have 2 young children, and it was a real struggle for us as homeowners to think that we were putting our children in harm's way. And since that moment, from the moment that we moved in, I've been pretty involved with the community in trying to get some protections for citizens who live so close to these drilling sites. The North Area Neighborhood Development Council did submit a community impact statement when this originally came across that laid out a lot of the arguments about the health and safety issues that drilling sites so close to sensitive land uses entail. One noteworthy one that kind of touches on other issues that we often deal with in the policy committee of the NANDEC Neighborhood Council is without proper regulation, these sites are exposed and use lots of chemicals which could easily turn into fires. We live in areas where homes are 100 years old or more and made out of wood, and so it really is terrifying to think of the tinderbox that we're living in with historic homes and resources in areas that are protected by other land use privileges being totally exposed as a result of proximity to oil drilling sites. So I'm here again to restate the case that NANDEC has already laid out in documentation that you already have received, to urge you to not to just vote down the appeal, to make sure that there is a buffer zone established of 2,500 feet between residences and other sensitive land uses and oil drilling, and to try to protect children, residents, the elderly, any people that unfortunately live within such close proximity to these sites. It is quite a densely populated area, one of the most dense in the county. There's a lot of human health at risk. I'm sure you'll hear a lot about it from some of the community members that are here today, because as I mentioned, there's a lot. We've dealt with this quite a bit as a neighborhood council. And so I'm just here representing the council to urge you to deny the appeal. Thank you.
Thank you. Item number 5 is case number ZA 1965-17528-PA5-1A. The site is 1349 to 1375 West Jefferson Boulevard in Council District 8. An appeal of the zoning administrator's determination to require corrective methods and impose additional conditions for the existing oil drilling and production operations at the Jefferson drill site. I'm going to pass on to staff at this time. Mr. Irving?
Okay, thank you very much. The services 4 oil drilling districts. Oil drilling district number 104, 124, oil drilling district 134, and oil drilling district 135. Now, with the exceptions of some intensification and changes approved by prior plan approvals, presently the oil drilling facility consists of 36 wells. 28 of them are active, 8 are idle. As for the types of wells, 27 of the 36 wells are producing wells and 9 are injector wells. Of the active wells, 20 are producer wells and 8 are injector wells. The oil site is improved with approximately 7-foot high block wall fence that surrounds the property. It is a 1-story structure consisting of a warehouse, electrical room, office, and a 1-story structure consisting of a workshop and welding shop. The areas for parking and pipe storage are provided throughout the oil drilling site, and the area has provided for storage of tanks and scrubbers. Can I get you to the next slide, please? So this is an inventory of the wells as of June 2017. Next. The site is located just west of Vermont Avenue, probably half a mile west of it, as indicated by the subject diagram on the screen. Next. The site consists of 2 zones. The commercial zone is at the lower half of the site. The residential zone is at the, now's the time to pull out the pointer. So the lower half is commercial zone, the upper half is your residential zone. On the east side of the site is residential properties, on the west side as well as residential property, and then there's some residential uses north of the site as well. Next. So this is the site, this is a configuration of the site. These are where your drilling well cellars are located. This is where your 1-story structures are and your workshops are located at here. Next. So this operation is governed by a number of actions that have been granted to this site. Initially in 1965, the first ZA approval was issued for the site. That's ZA 17528. That was initial grant. There was a second ZA case that was approved for this site to allow drilling within an adjacent drilling district. Following that particular item in 1999, the operators of the site submitted a plan approval to allow the transfer of ownership of the residentially owned property that they had into another ownership. Plan Approval 1, Plan Approval 2, and Plan Approval 3 were subsequent plan approvals approved by the Planning Department to allow drilling and re-drilling of additional wells and changing of wells on that particular site. Plan Approval 4 was a plan approval filed a few years ago, 2013, to again allow for the drilling and re-drilling of additional wells on this site. And then finally, Plan Approval 5, which is before us today, is the final action on that site. Next. So just kind of give you a brief rundown of Plan Approval 1 through 3. Plan Approval 4 is where most of this activity related to the site got stirred up. Plan Approval 4 was filed again in, I think, 2013. At the time the plan approval was filed, we started to have a hearing. There were 2 hearings scheduled. One hearing was scheduled and to be held by Zone Administrator Sue Chan. That particular hearing was canceled. At that time, it was pointed out that the notification surrounding that particular hearing was faulty, and we could not proceed with the hearing. Subsequently, the applicant, or the operator at that time, refiled, corrected the notification process, and we went on to have a hearing. That hearing was held by Maya Zazeski. At that time, Maya took testimony from all those who attended the hearing. A lot of the issues that were raised in the Plan Approval 5, and we'll get to that later, a lot of those issues were raised in Plan Approval 4 were raised in this initial Plan Approval 4 public hearing. The concerns about noise, traffic, odors, a lot of the same things that were shared with this zone administrator in Plan Approval 5 was shared with Maya Zazeski in Plan Approval 4. So that took place in November of 2014. Maya took the case under advisement, expecting to look into the matters that were raised at the hearings, the issues that were raised at the hearing. Within a month or so, I think somewhere in January of 2015, the operators sent a letter to the Chief Zone Administrator asking that Plan Approval 4 be withdrawn. The Zone Administrator granted the operator's application and withdrew formally Plan Approval 4. But with that being said, a lot of the concerns have been heard and have been registered with our office, and we knew about them. We went ahead and asked that the operator file a Plan Approval 5 so that we could formally address the issues that were raised at the hearing in Plan Approval 4. Our invitation to file a Plan Approval 5 was rejected by the applicant at that time. We then decided to move forward with having a city-initiated plan approval so that we could address the concerns and the conditions related to that oil drilling site. We conducted a public hearing. That public hearing was last January around this time. And subsequently, we issued a determination letter in October 2017. Next. Now, one of the issues that were raised in the appeal is the zone administrative authority to conduct these matters. The city has general police power to impose regulation reasonably necessary to protect the health, safety, and welfare of the public. That's our general police power. Our municipal code, specifically as it relates to oil drilling operation, we have additional power to impose conditions on oil drilling operations. Furthermore, we have additional powers if we find it necessary to impose additional corrective actions if it's determined they are required for oil drilling operation. And then finally, specific to this site, there's a condition number 21 of the original grant that clearly states that the zone administrator reserves the right to impose additional corrective actions if he feels they need to be taken. Next. Furthermore, in Plan Approval 2 and Plan Approval 3, Conditions 8 and 10, we made it very clear to the operators that we have the right as zone administrator to impose additional corrective actions if it is in our opinion such conditions are proven necessary, and we seem that to be the case. Next. So we issued this determination letter. This determination letter is not an approval of the facility. The facility has already been approved to process and have oil drilling activities. That has been stated with the plan approvals 3, 2, 3. These are simply restatements of the conditions and consolidations of the prior conditions. We took conditions from the original grant, from plan approvals 1, plan approvals 2, plan approvals 3. We consolidated them. They were restructured so they're much more easily readable. The conditions, for the most part, are out of the municipal code, section 1301, which are part of the original grant from the plan approvals. Again, as we are required to do, if we find it necessary to provide additional conditions, we will impose that. We consulted with the patrol administrators about what are some current practices, and we impose those current practices as additional conditions. Next. Zone administrative determination consisted of a number of conditions, and I'm just going to go over a couple of them. There were non-compliant conditions, and then there were revised conditions, and subsequently some new conditions. So this is a couple of examples of some non-compliant conditions. For example, if the first test well is proven to be successful, a permanent type of attractive covering needs to be provided. That was established 50 years ago. That has not taken place. Secondly, as a part of the original grant, a certificate of insurance carrier had to be provided to the chief zone administrator. We have no evidence of insurance for over 50 years. Surety bonds. As each operator changes, a different set of surety bonds must be provided to the chief zone administrators. A review of the plan approval records and original grant do not show that they're current on the surety bonds. So you'll see a lot of that throughout the determination letter. I did add some language or revise the language because for a plan approval, we want to make clear that we would like to have a compliance with these conditions submitted to us so we can be assured that these things take place. So there's a revised condition as it relates to plan approval. Next. And yes, we did impose some new conditions. As I pointed out earlier, it is within our authority to provide additional mitigation or additional conditions if we deem them to be necessary based on the testimony and based on review of the records and based on review of the site. We find that these are necessary. These are conditions that come from the best practices that are now taking place with oil drilling facilities. So they're not way out of the ballpark. They're really, for the most part, standard conditions that current operators do, such as, again, showing compliance with the conditions of operation. That's standard. Next. So these are the appeal points that were made by the appellant. Basically, it says that Section 1301 does not give us the authority to impose these conditions. They basically said that anytime this can only take place when someone files an application for a new oil drilling operation. That is simply not the case. I've shown that earlier, that Section 13 of the municipal code does allow us to impose not only conditions for a new operation, but if we deem it necessary to impose additional conditions, we can do that. Okay. There's a reference to the zone administrators not having proper findings because they're not based on actual observation. It is their contention that the zone administrator must be out there observing these activities. That is not the case. The city has always interpreted actual observation to be observation that could have taken place by residents, and we'll see some photos of those residents or anyone else in the community. So we see some photos of those next. Next. There's some reference to the fact of prior conditions that govern the use of that site, the restatement of the original grant and the plan approvals 1, 2, and 3. Simply, that's all we have. They've been revised, they've been made contemporary, and yes, we've added a couple of new things. As the Southern California Air Quality Management violations are not ongoing correctly, but I mentioned in that just the indication that this 50-year operation still has some problems. Again, they made reference to our inability to impose testimony solely based on impose conditions based solely upon testimony. Our conditions were not established based solely on testimony. Again, I've shown you where we reviewed the public record, and there's a lot of non-compliance with the conditions of approval. And the plan approval 5 determination requires extensive construction. The condition that it require a permanent facility that's always been there. It would have been extensively cost prohibitive back then, I guess. It's still going to cost a lot of money, so we can't get into whether this is going to be extensive construction and the cost of that. We just know that there's a condition that the operators have failed to comply with, and we're seeking that they comply with that condition. Next. Again, there's some reference to a public nuisance. Again, this is not a nuisance proceedings, so we're going to stay clear of that. They said that we abandoned our reliance on condition number 10 and PA3, but it's no longer operative. This oil drilling facility operates under, again, a set of conditions. I've shown you the case history. Cases, PA3 is what's regulating the site right now. So it's erroneous to say that it no longer applies. PA3 is a governing document for this site right now, and all conditions related to PA3 apply. They say we improperly raised new violations for the first time in the PA5 determination, as I indicated before. Many of these conditions were raised a few years ago during a public hearing held by Myers-Ozeski. The operators at that time knew about these items. They were documented by members in the community. They were made part of public PA4. They were there in the file. The representatives from PA4 heard that testimony held by Myers-Ozeski in 2014. These violations or conditions are not new. They've been around and for many years. And so I disagree that these are new violations and they're made for the first time available to them. That's just not the case. I want to operate as public vested rights. Again, this is not an infringement on vested rights, simply a restatement of all the conditions in one document. So we're not imposing on their rights. These are conditions that they have been made aware of. The original grant, PA1, PA2, and PA3. This is not a violation of any constitutional due process. Again, we're just restating determinations, conditions of approval, and whether these are feasible and practical, they've always been on the books. They could have been contested many years ago. Again, these are conditions from the original grant and the subsequent plan approvals. Next. So this is a site. This is a Google map of the site. North, you'll see the residential uses, and to your right are the residential uses, and to your left additional residential uses. These are low-density multifamily residences. At the lower half of the screen, there are commercial uses to the east and west of the site, and again, south of the site. Next. Mr. President, that concludes my remarks. I ask that you support the zoning administrator's decision, deny the appeal, sustain the decision of the zoning administrator's office, and that concludes my remarks. Thank you.
Thank you, Mr. Irving. Are there any questions at this time?
Commissioner Willis, you specified there are a certain amount of wells that are active, and can you elaborate and explain what this entails?
I'm at 38 wells established on the site. And let's see, let me get my numbers back in front of me. And so there are two types of wells. There are producer wells and injector wells. Okay. Now, as I indicated, 28 are active.
Okay.
Okay, so 10 are inactive. Of the 28 active wells,
Right.
20 of those are producers wells. Those are wells that actually extracted oil out.
Okay.
Okay. And it gets separated, the oil, gas, and water and all that stuff gets separated and go different locations.
Right.
And then there are 8 injector wells, and that injects water back into the ground to fill the cavity that's been created by the removal of the oil.
Okay. Thank you very much.
Any other questions?
Stern. I had a question about when there is maintenance on these rigs. There is supposed to be something filed with the zoning administrator, is that correct?
Yeah, there should be a filing whenever, we have a condition that says whenever you pull building permits, okay, you should be notifying the zone administrator. And so permits have been issued by the building department for many years. And as I indicated, this was first granted an approval in 1965. So they pull permits to change equipment in and out. Building safety had issued these permits. The operators over those years have not saw fit to make us aware that they were seeking these permits. To building safety's defense, and we have to take some responsibility for it, our conditions weren't very clear, and so some of that got through the cracks. So part of what we're trying to do right now is remedy that situation, make sure it's clear. Whenever you go get a building permit, we need to see that you're in compliance with the conditions of approval.
Okay.
So there's some shared responsibility here on that.
Thank you.
In this, you talked about the environment, how the smells and odors are affecting the residents and also killing the environment. The producer well and the injector wells, which one has more fumes, or are they the same?
So the odors and the fumes that are in the report were largely reported for activities related to routine maintenance. Some of the chemicals that were used to maintain these wells created a rotten egg kind of smell because of the chemical makeup. Okay, so that's kind of where a lot of these smells came from. I didn't hear any testimony about smells coming directly from the removal of oil and gas or the injection of water to replace it. What I did ascertain from the testimony was that it came as a result of, the smells came as a result of the maintenance activities.
Okay, thank you.
Okay, we will now hear from the appellant operator, and I understand there'll be 2 speakers, Nikki Carlson and Christine Haley, is that correct?
Yes.
Okay, and 5 minutes apiece is what you're seeking?
Yes.
Okay.
Nurse and staff and members of the public, I'm Christine Halley. I'm a director with Sentinel Peak Resources, and I hold responsibility for environmental health and safety. There's a lot of material to cover here in a 5-minute span. I'm going to try to get right to it. You know, we took over operations of this site about a year ago, and I looked at the back and forth between the city, the prior operator, and the dialogue that was being directed our way. And I thought, boy, I'm seeing early indications there are, I'm expecting to find evidence of failures to comply with the conditions that the city approved the operation of this 50-plus-year-old facility. And I began looking for that. And I just have to tell you that that's not what I found in review of the records. both in review of the records with the city and the more than a dozen different regulators that hold authority over regulating the operations at this drill site. To the contrary, what I found was a different story, and it was one of being very respectful of the neighborhood into which we operate and produce oil and gas. I wouldn't be surprised if we're seeing some reaction from those that are behind me right now. That's quite a bold statement, and in 5 minutes I'm going to try to get right to it. Let's talk about briefly what the Jefferson facility is and what it is not. A Jefferson facility is a location from which oil and gas that is very valuable to us as a community is produced. It is not an ongoing active well drilling site. The last time a well was drilled on this site was 10 years ago. Just please be aware of that. And when we do propose to drill wells, we do come forward to the city and we do secure city permits from the zoning administrator and others to proceed with that work. So there is one inaccuracy I would draw your attention to in the matters that have been brought forward. Let me mention what the Jefferson facility is not. It's not a refinery. You're not going to find open tanks with vents of emissions and smelly gases going into the air. That's not what you would find at all. All the mechanical apparatus are in enclosed systems. They're all on recovery of those vapors, and the Air Quality Management District holds permits, sends inspectors on site, and our own operators regularly make sure that those systems are operating and in good working order. But I made kind of a bold statement a minute ago where I told you, I say we're being neighborly. And I want to give some thought as to what would you expect that to be neighborly? You would expect an attractive wall around the facility with some attractive landscaping. I noticed that none of your street views that depicted the setting of the Jefferson facility reflected what you'd actually see from eye level. It's an attractive block wall with very nice landscaping. We're quite proud of it. We keep up on trash pickup, etc. We have limited hours of operation. We operate in quiet mode with respect to the setting that we're in. Agency representatives are welcome to come on site, and they do come on site, including your fire department, Air Quality Management District, and a whole set of other regulators, those that particularly keep an eye on chemical usage, delivery, and handling. It's all well regulated. I would be happy to work with your staff to draw attention to the wide array of kind of touch points of compliance that we can demonstrate in this regard. So what I see, you have a rebuttal letter from us dated the 5th of January that is exhaustive. It goes touch point by touch point on all the matters that we want to clear up in the city's own records with regard to this facility. And also, I can't emphasize enough what I have learned in the time that I've been directly involved in the oversight of this facility. I'm incredibly proud of the people that operate this facility. I've got Tyrone King here with me this evening. He's our lead operator at that facility and has been affiliated with that for many, many years and can speak to multiple generations of operations at that facility. So my appeal to you tonight, in summary, is we've got things to clear up in the city's own conditions that were put forward. I have serious concerns about the feasibility of some of the conditions, guys. A 45-foot wall is going to require a footing to anchor it properly to meet your city building requirements. That's going to rip out all that vegetation, impact overhead lines, and it's I will say this, grossly out of scale with the character of the neighborhood in which we sit today. I don't think that will be a welcome addition. It's just one I want to point out. But I have a feeling we'll be talking more as the night goes on. Thank you.
About your hours of operation, what are they specifically?
You know, in the plan approval itself, it stipulates when deliveries can come and go from the site, and when we are restricted into operating into a quiet mode, and those are in sync with kind of people's coming and goings from their residences. I'd have to look up particularly the hours. Okay. Yeah.
I mean, my question to her, yes.
Identify yourself, sir.
I'm Tyrone King, Senior Field Foreman, SBR. The operations hours are 7:30 to 6 p.m. After 6 p.m., all I want to see is brake lights. Nobody should be working except the operators that are just sitting there maintaining the facility.
And that's Monday through Friday, correct? Thank you.
Good evening, Nikki Carlson with Alston and Bird representing Sentinel Peak. I'm going to get to it. I don't know that we'll cover everything in 5 minutes, so we're available for questions. We gave you a lot of material. But we think there's several serious errors in the process here, so let's go through them and appreciate the zoning administrator identifying our appeal. Sometimes we get it right, sometimes not so right. So the important point here, we've learned about these violations for the first time in this decision. Planning approval 4, which he refers to and says we had knowledge of planning approval 4 and what was going on there. The patrolling administrator's report, which is the basis for the violations in this decision, was not available at that time. It was not prepared until last September. And so learning about these particular violations, and I'll go through exactly what those are when you sift through all the information, that's a procedural flaw, and it should be sent back to the ZA for that reason alone. So what started this process? It was 4 items in a letter from the ZA basically saying there were people, third parties, making barbecues on the sidewalk. There were complaints from the neighborhood on 2 different occasions, none of which were substantiated, by the way, which I think is an important point, and a violation from the South Coast Air Quality Management District regarding the failure of a piece of equipment, 1 issue, and we addressed that immediately. Those were the 4 items that were listed in the correspondence, and that was it. So when we got this decision, 50 pages, you bet, it was a surprise. So furthermore, one of the other process errors is that you cannot rely on unsubstantiated complaints. We appreciate the observations of the community, and they can be helpful in determining what is going on. But it's important for the city or some other government agency to substantiate those. And why? Because otherwise we don't know what to do. If there are things that are going on that we need to address, we need to be specific. Ask the question in terms of, is it the wells where the odor is coming from or something else? What is it that's causing a problem? Because Sentinel Peak wants to make sure that it is a good neighbor and to know, but unsubstantiating complaints about things, it's not helpful and it's not sufficient for a decision. Maintenance. You raised the question with respect to maintenance. It is completely untrue that there were building permits issued by Building and Safety that we did not get permits from the city. What is listed actually in the Petroleum Administrator's report is some 40-odd permits that were obtained from Dogger, not Building and Safety, all of which was within Dogger's exclusive authority with respect to downhole activities, that is, any activities that are below surface, right? Those were properly done. Where we needed to get a permit from the city, we did so. Those are the plan approvals that you saw for all the redrills. The city also attempts to impose new conditions. This is not a restatement of existing conditions. These are new conditions. And let's talk about noise, because a lot of the conditions really relate to noise. There is not a single, not one, not historically, a single substantiated violation for noise at all in this entire record. So while there are community complaints with respect to noise, again, important to substantiate those so we know what to do. But the city has not substantiated not a single one violation for noise. So the wall, all of the other noise conditions that are here really need to be examined carefully because we don't think they're justified. Same thing for fire. There's new fire conditions here, but the fire department hasn't said there's any violations. Same thing for trucks. There's no verified violations for trucks or lighting. Air quality, I went through the 1 violation that we had. There have been no pending violations. The violations that have been identified, 2 violations over 15 years, they were resolved immediately. The facts here don't support these new conditions. So there were a couple of other questions that were raised and I wanted to address. Police power. Police power does not give the city the unfettered authority to impose whatever condition it wants. It's constrained by the Constitution. That's what it means. And what the city can do with its police power is adopt regulations. We've talked about that, talked about whether the city can update its oil code, but that hasn't been done. And they can't use the police power to just say and justify any condition that they want. Furthermore, Plan approvals 2 and 3, in fact, all of the plan approvals with respect to re-drilling expired by their own terms. They were drilling grants for a short period of time, 3 years, I believe, and they expired. So the one non-compliant condition that's identified to say we need to have the acoustical blanket around the rig, well, when we're drilling, we do. There's no rig out there. So that we can't possibly be non-compliant when there's...
Hi, my name is Anna Parks. I've lived in the community around the drill site for 20 years. I currently live about half a mile from the site. That's the farthest I've lived, of the 3 places I've been. Until about 3 years ago, I had no idea what was happening at this drill site. I had no idea of the severe health risks that it posed to our community. But our neighbors began to come together to do research and to share their experiences. And I was appalled to learn about the high quantities of dangerous chemicals that were being used routinely just feet from single-family homes in the midst of a dense neighborhood. We learned that people were dealing with fumes, loud noises. In past hearings, there's been recordings of the noises presented. People were dealing with headaches, sore throats, and breathing problems. What we don't know for sure is what the invisible and long-term effects are on our bodies of having these high quantities of chemicals in the air. I work with, I just want to say I believe that the restrictions that the city has proposed in their determination are a bare minimum of what should be done to protect our community. I work with a tutoring center that's on Jefferson Boulevard. You could see it in one of the maps that was presented. It's within eyeshot of the drill site. And 2 summers ago, we decided to educate the kids about some of the chemicals being used: hydrofluoric acid, endocrine disruptors, particulate matter. And it was a chance to give them a lesson in chemistry. I also used it as an opportunity to give them a lesson in writing. And I want to share with you a letter that my friend Gabriella in 4th grade wrote to the oil company after learning about some of how oil is pulled from the ground.
Is it a short letter?
It's short.
Okay.
The oil
Only because
company.
it's a student.
Go ahead.
Only because it's a student.
The oil company is a bad neighbor. I feel very mad because they are hurting kids. For example, with nosebleeds, cancer, asthma, and sore throats. I want to take away the oil company because people love their children and want to take care of their children. The oil company puts chemicals underground and in our air. We can never see the chemicals, but we breathe it and it hurts us. If I was 30 years old and the drill was still there and I was still breathing that air, it would be very bad. I want to have a job and travel the world and play softball. For this, I need to be healthy. All of us need to be healthy.
Thank you.
My name is Calissa Morgan. I'm a registered nurse and a credentialed school nurse. I support the city's decision to enforce stricter regulations on the drill site 5 blocks from my home. As a medical professional, my purpose is to create paths towards health and healing, and I feel obligated to advocate for the reduction of disease-causing toxins in our environment from all sources. The chemicals used and stored at the Jefferson drill site include carcinogens and those that disrupt the endocrine and central nervous systems. Members of my church community a few blocks from the drill site have suffered from cancer, miscarriages, seizures, psychosis, adult-onset asthma, migraines, anxiety, and depression. It is difficult to fully quantify the financial and emotional burden a community suffers from chronic disease. Medical care, lost work days, lost school days, disability, and death are just a few ways of beginning to measure the cost. Good health is an essential resource to a successful community. I hope it is clear that investing in the health of our community far outweighs the financial costs and growing pains the oil company will bear as it learns to more thoroughly protect us from its toxins. As a city, we need to look to the future with hope, creativity, and integrity as we consider how to become a safer, healthier, and stronger community. In November, some employees of Los Angeles oil drilling companies testified that they had worked in oil drilling for several years and had not suffered any health consequences. I would like to point out that the employees are required to wear personal protective equipment when they perform certain functions, including full hazmat suits. However, the people walking on the streets next to the site, the people sitting in their homes with the windows open next to the site, and the children attending tutoring across the street do not have personal protective equipment against the fumes, and they rarely have meaningful advance notice of scheduled drilling. Thank you.
Thank you.
Hello, my name is Longdi San, and I am a resident of, I've been a resident around the Jefferson drill site for the past 7 years. And I'm just a resident who's concerned about the well-being and health of the community that I live in, right? And so I just want to make sure that the people in that community are cared for, and not just, and we're not just limited to the economic interests of big oil that's located within our company or within our residential neighborhood. Yeah, I'm particularly concerned with the different layers of risk that are present in terms of, the diesel trucks that are, transporting the chemicals to the drill site. Just constant exposure or regular exposure to diesel fumes can be carcinogenic, along with the use of certain chemicals, whatever hydrofluoric acid, that are skin and mucous membrane irritants. There's also the use of endocrine disrupting chemicals, right? They interfere with the communication in our organ systems, ultimately affecting our developmental and mental health over the course of time. So I'm just concerned about that. And I want to make sure that, that some of the hazards that are associated with conducting this sort of business in our community is made known. Thank you.
Thank you. Yes.
Great. So I'm
your name,
Hamilton.
please.
I'm a resident right across.
Can you say your name again, please?
Sure. Hamilton Yang. I'm a resident at 3031 Van Buren Place. I live less than or around 100 feet from the drill site. So I want to address a couple of things that Sentinel Peak just brought up. I have lived at that particular address for the last 2 years. So I've seen the site operate both under Freeport as well as Sentinel in the entire time that they've had control of the site. And many of the practices that I saw that were very concerning under Freeport has continued under Sentinel. So whatever they say about being a good neighbor, well, I'm right there. I live, I can see it from my front door. They have trucks coming in and out. They even attest to that their hours of drill operation are from, as early as 7:30 a.m. So just to give you a picture of, who I am and what my home life is like. So I work at a cybersecurity software startup, and that means I often have to work from home. I also have a wife who has a permanent medical condition that makes it so she also has to work from home oftentimes. We live in a house that's around 100 years old, and whatever quiet mode operation they're claiming to be doing, it is so loud that even with all the doors and windows closed, I can hear, the noise is overwhelming to the point of waking me up when I'm in the room furthest from the drill site. Okay, so that's within a structure, multiple walls and doors in between. I get woken up early in the morning by the drill site operation. So, I have, and also as a close neighbor, I can just pull out my phone and record these things. So I am happy to submit, my corroborating evidence for the impact that the drill site has on the surrounding community, and I can also attest to that personally too. So I support the commission's decision to impose stricter operating guidelines for this drill site. Thank you.
Thank you.
Hello, my name is Andrew Wong, and I live just a 10-minute walk from the drill site. But today I would actually like to share on behalf of one of my neighbors who lives quite a bit closer. Mrs. Mary Harris is a resident who lives just 2 houses down from the drill site. She and her husband reside at 3016 Van Buren Place, and they've lived there for 4 years. She was unable to attend today's hearing, but she still wanted to share her concerns with the drill site, and I have a copy of her letter to submit into the record. Mrs. Harris's experiences constant loud noises from the site. She says that the disruptions of the drill site cause her to feel sluggish and not well rested. But when she spends the night at her daughter's home, which is in another neighborhood, she feels alert and ready for the day. The quality of life is very different in that other neighborhood. Mrs. Harris's experience is just one of many throughout the neighborhood that reveals how the Jefferson drill site is indeed a nuisance that disrupts the daily lives of residents. Commissioners, we strongly urge you to deny the appeal of this determination and to instead protect and preserve the public health and safety of children and families in our neighborhood. Thank you very much.
Thank you.
Good afternoon, Commissioners. My name is Richard Parks. I'm a 30-year resident of the community and president of Redeemer Community Partnership. I want to make 3 points here, and that is that these conditions are necessary, they're reasonable, and yet at the end of the day, they're also insufficient. So let me start with just the fact that they're being necessary. You should know that homes next to the drill site and cars parked on Budlong Avenue have been sprayed with oil multiple times over the years. You should know that ambient acid fumes from the acid maintenance jobs that they do at the site have been so intense that the ambient fumes have killed plants on the downwind corner of the drill site. You should know that closed windows cannot keep out the petroleum odors and the diesel fumes from our children's bedrooms' windows. You should know that the deafening din of thousands of feet of pipe being driven into the ground and removed has robbed residents of the peaceful enjoyment of their home. You should know that these acid jobs, workers stand on one side of the wall, you have photos of this, in head-to-toe protective gear, pumping literally tens of thousands of gallons of carcinogens, air toxins, endocrine disruptors. These are chemicals that disrupt reproductive health across generations without any notice to residents.
My name is Nicole Wong. I'm the lead community organizer with Redeemer Community Partnership, and I live about half a mile from the Jefferson drill site. In my role, I've spent a lot of time listening to the stories of my neighbors impacted by this toxic drill site. One neighbor who wished very much to be here but couldn't is Lillian. She lives 3 houses away from the site for 30 years and has endured loud noises, toxic fumes, and oil has even sprayed out from the site onto her car on the street. She's witnessed her son's spontaneous nosebleeds. She's attended funerals of neighbors who have passed from cancer. And the reason she can't be here tonight is because her husband is currently in the ICU, suffering from the cancer eating at his lungs. Can those of you who are here against the appeal please stand? So tonight, families, children, and residents are here to stand for a healthy future. We know what the routine chemicals are being used for, and they're required to operate, and it's not compatible with a healthy community. It's common sense. We urge you to deny this appeal. This drilling site is a public health hazard. We urge you to be part of making a future where families and children in South LA can live healthy, safe, and opportunity-rich lives. Thank you.
Thank you.
Pasillas. I live just across from the drill site, about 200 feet away, at 3031 and a half Van Buren Place. I'm here to confirm that although perhaps there hasn't been substantiated evidence of noise complaints being found or air quality being, determined. As someone who lives there and experiences this regularly, I do freelance work from home. During the hours of operation, the noise is, as our other neighbor said, so loud that I have to close all the windows and doors because the rigs, or I don't know what the proper term is, the tall rig, is dropping metal pipes into the ground from hundreds of feet above, and that clanging literally shakes my house. My home. I can see the water in a water glass just like rippling. So it feels like small earthquakes. That to me is unsafe and not a good neighbor to be producing that much disruption to your neighbor. And I believe there's a constraint or somewhere it says that the noise should not be above that noise of the regular traffic in the surrounding area, and that's certainly not true. It is extremely loud. It keeps me from focusing, it keeps me from working from home, it keeps me from holding teleconferences. I basically cannot do my work on a daily basis from my own home and have to leave to do that. In addition, every time there's an acidization job and I smell the diesel fumes, they permeate my home, and I get headaches and nausea. So with a little bit more forewarning, I've learned that I need to leave the house when these acid jobs are occurring. And I don't feel like I should have to leave my own home, and that it should be such an unsafe place for me to live in. So I urge you to please deny this appeal and for the safety of us.
Thank you.
Hi, my name is Janelle Luck. I've been a resident for 9 years in the area, and I'm here with a letter that a neighbor has written, so I'm here on behalf of her. The neighbor is Isadora Lee Cintron Moya, and she's a resident who's living literally next door to the drill site. She's been there for 3 years at 3023 Budlong Avenue. She wasn't able to attend today, but I wanted to share her concerns with the drill site. And I have a copy of her letter to submit into the record. She experiences loud noises from the site, as well as toxic smells. She also expressed concern that the daily contamination the site brings into the neighborhood is the cause of the health issues she has experienced. Isadora's experience is one of many throughout the neighborhood of how the Jefferson drill site has created problems and disrupts the daily lives of residents. Commissioners, we strongly urge you to deny the appeal of this determination to protect and preserve the public health and safety of children and families in our neighborhood. Thank you.
Thank you. Kyle Apuna.
Hi, Commissioners. My name is Kyle Apuna, and I have lived in the neighborhood for several years. I live near the Jefferson drill site, and I honestly ride my bike past that site every single day. I'm here to speak on behalf of one of my neighbors who lives a lot closer than myself, who was not able to attend today. Jeremy Allam, he's a resident who's lived 100 feet from the drill site for 2 years now at 3019 Budlong Avenue. He was not able to attend today's hearing, but wanted to share his concerns with the drill site, and I have a copy of his letter to submit to the record as well. He experiences the toxic smells as well as loud noises from the site. The presence of the drill site impacts his daily life by causing him to lose sleep. Jeremy's experience is one of many throughout the neighborhood of how the Jefferson drill site has created problems and disrupts the daily lives of the residents. Commissioners, we strongly urge you to deny the appeal of this determination to protect and preserve the health and safety of our neighborhood. Thank you.
Thank you.
Good evening. My name's Gabby Santos. I live less than a mile away from the drill site and work at an after-school tutoring program as a teacher for elementary students half a block from the drill site. As I walk past the site on a regular basis, I've experienced the loud noises, toxic smells from this drill site, especially from the tutoring center. There would be many days when we would have to keep doors closed due to loud noises from the site so that kids could stay focused on their homework. There would even be some days where kids would experience nosebleeds or problems breathing. It saddened me to learn that nosebleeds and respiratory issues are common side effects associated with oil and gas activity, especially in young children like my students. I'm absolutely heartbroken to know that the toxicity of the site could be damaging to their health. No child or person's health and safety should ever be put to risk. Commissioners, I urge you to deny the appeal of this determination. Thank you.
Thank you.
Hi, my name is Jennifer Blue, and I live half a mile from the Jefferson drill site. I'm here today as a mother of 3 children. In the last 9 years, I've had 2 miscarriages. If any of you have ever lost a child, I think you can understand the pain and the sadness with that. When I learned 5 years ago that the previous operator had been pumping, thousands of pounds of toxic acids and chemicals under our homes, I was appalled. Appalled that oil drilling is allowed in residential communities.
I'm appalled that our community does not have the same protections that were granted 20 years ago to other communities in the city of Los Angeles. These conditions are very reasonable. Could my own miscarriages be affected or somehow the result of these toxins? I have with me a study from 2014 on the developmental and reproductive effects of chemicals associated with unconventional oil and natural gas operations. The easy gas has been extracted years ago, decades ago, and so they're pumping acid into the ground to extract whatever remaining gas is there. It lists the effects: semen quality, menstrual cycle, miscarriage and stillbirth, preterm birth, low birth weight, birth defects. These are not small costs to pay. I have a friend 2 blocks down. She has suffered 3 miscarriages in the past 10 years. Another friend 2 streets over suffered a miscarriage. Another friend who lives half a mile on the other side of the drill site has had 3 miscarriages in the past 10 years. Another friend who lived 0.3 miles from the drill site had 2 miscarriages. How many more miscarriages do we have to have? I urge you to stand by the zoning administrator's decisions and the city's decisions to protect our health. Thank you.
Thank you. Commissioner, of the toxic acid and chemicals pumped under your homes, did the residents receive proper notification regarding that?
I've never received notification.
Okay, thank you.
I do have the study I can also see.
Okay, you can hand it to me.
Elliot Ling, and I've been a resident in the neighborhood where the drill site is for nearly 15 years. And along with my wife, we have the privilege of raising our 2 girls in that community where we work, we live, we play, often very close to the drill site. My older daughter, Josie, she's 4. She just finished her first season of t-ball this past spring and soccer this past fall, a half mile from the drill site. It was mentioned that a 45-foot wall may not be appropriate for our neighborhood aesthetics. My question is, how much less appropriate is an active, uncovered, open drill site immediately adjacent to homes where children and families live? It was mentioned that a severe violation with fire has not been noted. Should it be a prerequisite for protections that the West Side and our fellow Angelenos enjoy for a fire to burn down a home near the drill site? Should the burden of proof for the dangers of this drill site be on our children's health, or should it be upon the drilling company, the oil company, to prove unequivocally, without doubt, that it is safe for the children and families who live in that neighborhood? So out of concern for the health and safety of my neighbors, for a desire for justice, and just some basic common sense, I plead with the commissioners to reject this appeal, the request for appeal. Thank you.
Thank you.
Hello, my name is Danielle Cummings. I've lived in this neighborhood in the zip code for 12 years. We are raising our family here. Formerly involved in education, I now primarily am a mother and a neighbor. This morning, my 1-year-old and I cleaned our windows, trying to reach between the bars to remove the pollution and grime. I tried to feed him healthy snacks and lunch. My older sons worked on homework before coming here this afternoon. Yesterday, we read a book about Martin Luther King Jr., a man who spoke truth to power, conviction to complicity. As much as my peers and I try to provide clean homes, good food, and education to our kids, there are things outside of our personal scope. We don't choose that 3 feet from the nearest home and 730 feet from an elementary school is a huge oil drilling site, willfully neglecting established standards and endangering our health. We are here today relying on you to do the right thing, the long-term thing, the thing that our kids and your kids could celebrate. Reject the appeal of the corporation and affirm the life of our community. Insist on environmental justice and truth. Thank you.
Thank you. Michael Jones.
Hi, my name is Nathan Smith. I live at 31 and a half Van Buren Place, just across the street from the Jefferson drilling site. I've lived there for approximately 4 years. And today, when I hear that the oil drilling company desires to be a good neighbor, I can appreciate that. I can appreciate that they are keeping up the facade of their location. But what I cannot appreciate is that they would be so dismissive of what we as a community have, the concerns that we have. To say that they desire to be a good neighbor, but to respond to what we have to say with such dismissiveness and call it unsubstantiated, I think it's just it's not good neighborly, and that it doesn't communicate to us that they care about our well-being as the people who live right across from the activity. And they may not be drilling new wells, but those rigs are still up. The sounds are still there. The smells are still there. I don't know how all the codes work. I don't know when they're being compliant and when they're not. But I can tell you what I see every day. What I see every day is not that they care about the impact that they're having on us as their neighbors. Thank you.
I have a question, Commissioner Antoinette Anderson. When you speak about...
Nope, come back.
When you speak about the daily noise, is it every hour? Is it every minute? How often is it?
No, it's not. It's unpredictable, and it's just, it's when you don't want it. That's all that matters. It's disruptive. I can't predict it. We don't often hear when they're doing routine maintenance. We don't get notice of that the majority of the time. I think there are a few times where they have to notify some governing board, but not us. So we just pay attention to the signs, and we sometimes, like my wife said earlier, she will leave the house to avoid it. But we don't know when it's going to happen, and we just try to do the best that we can. But it is disruptive.
Well, I have another question. The toxic smell, is it daily? Is it monthly?
It can be. Again, like activities we'll have a week or 2 weeks, and then it will quiet down for a little bit. But yeah, it'll be for hours at a time, or for the whole day. And I think especially for families who are at home for a large part of the day, they can't escape it, or they'd have to restructure their life in order to do that. So
thank you.
Mm-hmm.
Dr. Yelba Castellon-Lopez. I am a medical doctor. I also do research at UCLA, but I'm most importantly a longtime resident of the surrounding community, and I live within a 500-foot radius of the Jefferson drilling site. We all know that environmental exposures are a real threat on the health and safety of our neighborhood in Los Angeles County. We don't have to look too far back or too far out to recall some of the devastating effects of these environmental exposures. And as a local resident, I myself can attest to the strong chemical fumes that we smell living nearby this particular drilling site. Most recently in October, I came home early, and my 2 children who are cared for at our house, who are 1 and 4, were home, and I said, it smells really strong. And I asked my, mother-in-law, who's our babysitter and helps us with the kids, and she said she had smelled it all morning. So essentially, I called, and to speak to the, to the substantiation of our complaints. I did call all the appropriate numbers. Unfortunately, nobody came out until they actually called me the next day and asked if they wanted, if it still smelled, and I wanted somebody to come out and investigate, but not until the following day, at which point, I no longer smelled the fumes. But to make a long story short, that day I had to, being that I was pregnant and in my first trimester, I had to take my family and, basically spend the night at my mother-in-law's house. So fortunately, I'm able to do that, but I think the Planning Commission should reject the appeal. I strongly support moving forward with the zoning administrator's determination, and I think it's a step in the right direction. I think we need it in order to preserve the safety and wellness of our surrounding community, which I might add already deals with a disproportionate burden of disease.
I have one question for you.
Yeah.
Received. Who was that from?
South Coast Air Quality. control.
Okay, it wasn't from
They-
the operator?
They called me the day of, and they called me hour later and 2 hours later. And by then I said, I'm leaving. I'm not going to stay. Nobody's, coming out. And then Air Quality Control called me the next day and said that their investigators were tied up in other places, and they didn't have anybody to come out that day. So it wasn't until the following day that that they had somebody who could come out to substantiate. At which point I said, I don't smell it anymore. So.
Were one of the people you called the operator?
What I called.
The drill.
Yeah, I called
site?
them,
Okay.
and they called me back. They said that
Who's they?
the operator, I guess.
Okay.
And I called two numbers. So Air Quality Control was one, and then I called the company, and their operator called me back, and they said that they couldn't, substantiate the smell, but the smell was very real, so much so that I moved my family and myself out of my house, as some of, our other neighbors do as well. But in terms of other kind of regulatory bodies that should help us substantiate these things, weren't able to come out until the following day. So I think, that's obviously a concern and should be factored in.
Thank you.
Good evening, Commissioners. My name is Michael Jones, and I am a resident on West 26th Place, about a mile from the drill site, and I live 1 block away from the Murphy drill site, which is also operated by Sentinel Peak and connected underground. So, I would like to ask Sentinel Peak why they are so against these regulations if they think they are such a great neighbor. If you seek to be a good neighbor, comply with our needs and our thoughts. You should care for us. Perhaps then we would be more supportive if you actually were concerned with people's lives rather than oil from the ground. I would like to address the lawyer's claims that there are no meetings or barbecues on the lawn of the site. Since then, I could count numerous times as I've driven by and seen residents having a barbecue, enjoying the nice landscaping that they have, but they're not supposed to be there. They're right next to the oil drilling. I talk with my neighbors, and they talk about how these sites will never change because they're black and brown people who have been oppressed by these people for so long. It's never going to change. They're going to continue to be oppressed. I implore you, commissioners, you need to not go with these. You need to reject this appeal because these people, they just give up. We need to show them that you care about them. Thank you.
Thank you.
Hi, my name is Jocelyn Herrera. I'm a community organizing intern with Redeemer Community Partnership. I'm also a USC student, but ultimately I'm a resident of this community. I have seen the injustice of living so near to the Jefferson drill site through the stories of several of the community members, many of which are people of color. They experience noise pollution and horrible air quality on a day-to-day basis. Many of these families are Latinos who struggle with vocalizing the issues that they have experienced because of the language barrier. I've had to translate myself for them so that they can say what they want to say. Many families aren't even aware of the dangerous neighbor that is the Jefferson drill site because the Jefferson drill site doesn't take the time to warn them about the dangerous activity that happens behind the green hedges. People should not have to experience this injustice, so we urge you to deny this appeal and to enable these strong new conditions. If the people of West LA don't have to worry about their children developing asthma or their wives suffering a miscarriage because of the toxic chemicals used by oil sites, then the people of South LA shouldn't either. Thank you.
Thank you.
Hi, my name is Miriam Maldonado, and I've lived there for quite a long time. I sometimes wonder, what damage really is this causing my grandkids? We all have families. I'm imploring you guys to please help us. You see your grandkids, you want them healthy. You don't know. You can literally smell it everywhere. And you wonder, where's it coming from? What is it doing? And you wonder, where is it coming from? Of course, we all know where it's coming from. And there's, us little people can take that big corporation sometimes, I feel. And that's why I'm here, as the little person. I do care for other people's kids, for my own grandkids. You want to play outside, let them run, let them play it on their bikes. But you have to take them in because you don't know. Please help us. Please help us. Thank you.
Thank you.
Hi, my name is Maya Golden Krasner. I'm an attorney with the Center for Biological Diversity. As stated in the presentation earlier, the city has legal authority to update its permit conditions to protect residents. Sentinel wants to rely on decades-old, outdated conditions, but knowledge and science advance over decades. As we submitted in our comments, numerous peer-reviewed studies demonstrate health harms from oil operations, from oil extraction, not just active drilling, but also injection of chemicals, noise, diesel trucks, diesel equipment, and lights. We detailed these impacts in our letter, but they include everything mentioned here today, from cancer, endocrine, reproductive, and neurological harms to asthma, headaches, and nosebleeds. And I've got to say that Sentinel's dismissal of these complaints as, quote, unsubstantiated shows how much respect the facility seems to have for this community, and it's bizarre given everything that the neighbors have said. The conditions here are overdue, reasonable, and common sense conditions to address just some of these impacts. And they're not conditions that are just pulled out of the air. They're conditions that are already in place on the west side, including the enclosures like the one Sentinel complained about earlier. None of the requirements affect Sentinel's ability or right to drill for oil or extract the oil underground either. So I urge you to reject the appeal and uphold the ZA's decision. Thank you.
Thank you.
Hi, my name is Richard Louie. I live 3 or 4 blocks away from the drill site. I've lived in the neighborhood for about 13 years. I don't understand all the technical arguments. I'm just trying to raise a young family. I don't have time to read through all those different documents and all the things that they're saying. But I feel like I'm listening to President Trump talk about fake news when they're trying to spin the truth that there is no substantiated evidence of things hurting. And I rely on people who do know these things, who do studies and say this is bad for us, and that building a wall, these enclosures will be better. What I do know is that I have a 5-year-old and he gets nosebleeds once a month, if not once a week. That I'm going to have a baby we're due in 2 weeks. And that when I get sick, that I often cough and hack much longer than I used to before I moved into the neighborhood. I'm not a scientist. I can't substantiate that with some sort of report or study, but that's my experience. And so I urge the commission to take into consideration the safety of my family, of our community, and we rely on people like you to protect our community, and we urge you to do so. Thank you.
Thank you.
Jason Robinson had to leave early, so he asked me to speak on his behalf. My name is Jennifer Redekop. Jason Robinson is president of the West Adams Neighborhood Association, and he asked me to speak onto the record that the entire neighborhood association strongly urges you to reject this appeal. He's also my direct across the street neighbor, and we live a half mile away from the drilling site. Thank you.
Thank you.
Good evening. My name is Angela Johnson-Mazzaros. I'm an attorney at Earth Justice, and we're representing Redeemer Community Partnership in their efforts to raise this to your attention. I was really struck by Sentinel's representative saying that when she reviewed the record, she saw a record that showed quite a bit of respect for the neighborhood. And she said that she was going to show us, she was going to tell us what she found and about all this respectful behavior that she identified. You've just seen a parade of people who have told you they are not a respectful neighbor. So to grant Sentinel Peak's appeal, you'd have to believe a few things. You'd have to believe that the VA hearing in 2014 with the complete record, that the repeated requests for the operator to explain how the then existing conditions were effective in protecting the surrounding community. You'd have to believe that the public hearing that happened in January 2017, that the document more than 300 pages long that Redeemer submitted in 2016, you'd have to believe that none of that happened. You'd have to believe that they weren't there when the community talked to you about these same kinds of things that you're hearing now. Instead, you'd have to believe that Sentinel learned of the complaints about it, quote, when reading the zoning administrator's decision. It's just factually incorrect. You'd have to believe that the community residents' testimony about their lived experiences in this neighborhood are worthless, that they can't be trusted. And they certainly couldn't be the basis of action by the city of Los Angeles. You'd have to believe that Sentinel has a constitutionally protected right to extract oil in this community no matter how much disruption it caused. You would have to believe that the Federal Civil Rights Act prohibits the zoning administrator from writing a determination to make them monitor and control impacts from their sites. It's too much to believe. We hope you reject this appeal.
Thank you. Thank you.
I wanted to call back to one of Amanda Parsons. Great. I wanted to call back to one of the comments we received from a doctor in the community who mentioned she did call Sentinel Peak Resources when she had a complaint about an odor or a noise. And I wanted to point out to the community that there is a 24/7 hotline in place that any of them could call at any time. All of those calls are investigated by our staff, and we work hard to ensure that we are a good neighbor and can correct any errors that are impacting the community or reducing their quality of life. That number is 1-800-766-4108. That number has been in place for multiple years. In addition, I would like to say that I agree with Christine Halley and her remarks that additional time is needed for Sentinel Peak Resources to work with the city in order to explore viable alternatives for the site. Thank you.
Thank you. Good evening, everybody. Hi, I'm Tyrone King. Let me give you a little history about how long I've been in the oil field. My parents moved me out of Los Angeles in 1974 because I was hospitalized twice for 7 days, both times with asthma. They moved me out to Paris, and I was able to outgrow it, and I came back. And where did I come back to? I work in the oil industry. So as a young 38-year-old taking over the foreman of Los Ciennegas, it was really my first foreman job. Where I'm from, I said, I drink Starbucks coffee, I win safety awards, and I'll make this a country club. That was my ambition when I got there in 2006. When I went to the lease the first day, it was the worst lease I ever been on. There was trash everywhere. There was broken glass, there was furniture piled up, there was junk everywhere. We had just taken it over from a mom and pop, what they call a mom and pop operation. I spent 3.5 years working from 4:30 to 8:30 every night, talking with the neighbors in the neighborhood, walking the streets, beautifying, removing, repairing, just remodeling the whole thing. So when I get up there and these people are talking about the home away from home, being asthmatic, I couldn't breathe. I never got to play when I was a kid. I was locked up in the house. I was getting shots 3 times a week. For them to say that this place is toxic fumes and stuff, this hits me really hard because this is my home away from home. I look at this lease and I look at everybody in the neighborhood. I don't want to live with the fumes. I don't want to live with dirty water or dirty air. I breathe the same air everybody in the neighborhood, and I want everybody to have the same thing. So I take it at a point to make sure everything stays intact. Everything is held to the highest ability that I can. So I'm sorry these people are saying this, but I just wanted to give you my 2 cents. I love what I do, and I love everybody in the neighborhood. Thank you.
I have a question, Commissioner Willis. Why didn't you give the residents proper notification regarding the pumping of toxic chemicals under their homes?
You'll use for me?
Or?
Oh, okay.
Yeah.
Now,
You know, I believe you're referring
please?
to, excuse me, Christine Halley, Sentinel Peak Resources. And Commissioner Willis, I think you're questioning the use of chemicals in downhole applications. And that the use of such chemicals is governed by Division of Oil and Gas and Geothermal Resources. So any use of downhole chemicals we propose to undertake, we must first secure that permit and comply with the regulations under the state of California. So yes, we are pulling permits for that. And the public has the portal of information into the Dogger. It's like a cornucopia of information that's available about chemical usage overall in the oil production in various areas.
Okay, thank you. Commissioner Antoinette Anderson, I have a question for you, Tyrone. What is your attire daily when you're working with the chemicals? What uniforms or equipment you use daily?
We wear proper PPE. Proper PPE is a standard. We'll wear a mask is when you're doing something in confined space. That's been something that where the air oxygen is not between 19.5 and 23.5. So you would have to have some type of forced air or respirator. Or if you're sweeping up, you're going to have dust in there. You'll put on just regular dirt cartridge that you see anybody, they sell at Home Depot.
But you wear protective clothing every day.
I wear cotton, which has a spray on it that's FR retardant, so that if a flame hits you, you're not going to have a polyester that you'll just melt.
Into the mic.
Oh, that you'll just melt. So it's just regular cotton clothes with a spray of fire retardant on it.
But residents don't wear that daily.
They do because it's cotton.
But they're not sprayed with the SR or whatever you just described as a chemical retardant to fire.
But that's what the firemen wear too.
Okay. But when you speak of asthma, we know medically as a child people can outgrow asthma, and it's all due to the environment and what's
yes,
around.
and I remember those purple skies. I remember the 200 and some smog alerts that you never could see the marina until it rained or the wind blew. And you remember that too. This is because of the regulations they put on the different corporations. Now you have clear skies and blue skies, and our air is getting better every day.
Right.
Thank you.
Thank you.
Workers in head-to-toe protective gear stand behind red danger tape while residents a few feet away receive no warning. Is this what you wear daily?
I cannot see that. Can I come up?
You pass
No,
it?
can't.
Thank you.
Okay, this right here is a white Tyvek suit. They wear this. It doesn't have any kind of really property just to keep them from getting dirty on it. Green hard hat means he's a new guy in the industry because they usually wear a green hard hat. So when you have these guys that are doing any kind of confined space, they wear this so they don't trash their regular uniform. This is something that is disposable. They throw it in the hazard oily waste.
Okay, thank you.
This is Ernest Velasquez, City Attorney's Office. If the commissioners could just describe for the record what picture they were referring to, just as this is recorded and anyone listening to the audio wouldn't have been able to see what picture we're looking at. If you could just describe where you found that picture, document, page number, that would be helpful for the record.
Commissioner Antoinette Anderson, I was looking at page 6 from the document of the Jefferson drill site. Redeemer.
Do we know who provided that?
Who provided this?
Redeemer Community Partnership.
Okay, I couldn't read
It's a document from Redeemer Community Partnership.
Thank you.
Good evening, Commissioners. My name is Shayla Menti. I think many points have been addressed during this meeting today. We can mention some is language barriers, lack of knowledge, lack of notice, no prior complaints being addressed about the many complaints that we have filed in the past. But the bottom line is that this is our home, our community, and that we depend on you to give our families a healthy and safe community. I ask that you please reject this appeal. Bottom line is that you can really know what happens in the community if you just come twice a year and just have a random supervision. We live here. We deal with this every day on a daily basis. We shouldn't have no one here, or even the ones that are not here today to speak for themselves, should have to leave their homes because the noise and the smell is unbearable. When we decided to live in this community, we literally spent all of our savings. We invested all our money just to buy a home here so that we can give our kids something better than what we had before. I know what it is to live maybe in a small apartment building where our kids cannot even go outside and play. So when we purchased our homes in this community, we were planning for them to have a space to run, to be part of the community, and not to be locked in the buildings or inside doors because the smell outside, we cannot deal with it. So by hearing all of my neighbors here, it hurts my heart. And we cannot do it ourselves, but we depend on you. We ask that you please reject this appeal. Thank you.
Thank you.
Albisael del Valle. On behalf of the councilman, I really applaud the findings and determinations issued by the city zoning administration back in October 2017, and we ask that you deny this appeal. I fully support the planning department's effort to preserve the health, safety, and general welfare of the residential neighborhood surrounding the Jefferson drill site. I personally visited the site several times, and I personally know residents who have been affected by the drilling operation for many years. While there's similar oil drilling in other neighborhoods, the Jefferson drill site has operated for many years without due regard to its neighbors. I'm glad to see that we're requiring a soundproof enclosure like I see in other drill sites around the city and county of Los Angeles. This and other conditions, such as air quality monitoring equipment and electric versus diesel rigs, should not be reserved for more affluent communities, but rather they should be provided for all communities. Now, these corrective conditions, I believe, the councilman believes, and we all stand with our communities, they're long overdue. The neighbors of the drill site have been complaining about the health impacts and a range of nuisance activities related to the drill site for too many years now. They were well organized in documenting problems. The zoning administration heard their voices, and the city of Los Angeles is now taking action to protect their health and well-being, as we should in every area of this city. Thank you.
Thank you.
Resources. Listen, we do hear community concerns. We hear it. And it is obvious to me that we do need to work through consideration working with city staff regarding this site. And we remain open to talk about alternatives for this site that are compatible with expectations. I do feel compelled to mention something overarching here. You might feel like, boy, when you paint oil and gas production in this light, let's just wipe it out, make it go away. But I want to take a moment to consider what this would be like if that were the case. What we enjoy here tonight is brought to us people by hydrocarbon production. It's the heat in this room. It's the energy we produce to create the lighting here. It's the components of these apparatus and little gadgets we carry. It's my lip gloss. It's the prescription medicines that we take. This is what oil and gas production provides to us. This is creating the human environment that is the healthy backdrop of our families and our households. I stand here proudly to share that and to be a part of it. It is hard to hear your own production of a much needed commodity painted in this light. California, we cannot keep up with you. Oil and gas production in this state outpaces our ability to produce right now by a factor of 3. We can't keep up. So let us be very measured in what we consider as reasonable regulations around a much needed commodity that continue to provide, and we do it best right here. I do not want you to walk away feeling like the city let this community down in the manner in which the regulations are currently in place over this drill site. You have exhaustive regulations in place, regulations that do well to put safety guardrails on this implications. I do want to mention one thing in the short time I have left here. I hear a lot about concerns about chemical usage and health impacts. And we need to reassure one another that there are bodies in place that oversee, regulate, and come inspect us regularly. We're not expected as individual citizens to have to be knowledgeable about those. This is what our tax dollars and our regulators do on our behalf.
Thank you. The testimony of researching facts and making fair and timely decisions. On the other side of that is that we expect that sort of integrity to be forthcoming from those who wish we issue a decision letter. The zone administrators in 1965 expected a high level of integrity from the operators of this site. 50 years ago, a number of conditions were put in place, and it was expected of the operators then to abide by those conditions. It is expected now of those operators to abide by those conditions. It's the integrity by which we all are going to be made safe and whole by this whole thing. If we are not going to maintain the integrity of these conditions, then what you heard from the community is going to persist. If we don't impose these conditions and we don't abide by them, what you heard from the community will persist. And what you will hear from the operators will persist. They will not discuss their lack of integrity around these conditions. They will instead tell you that it's not your ability nor the city's ability to regulate this. Now, I'll step back one. The representative of Sentinel Peak said that the city of Los Angeles did not have police power to regulate that, and that's incorrect. The police power started with enacting or district regulations under 1303. That was the first level of regulations under police power, the first level that was put in the municipal code for us to regulate the establishment of district, the establishment of oil drilling sites, the ongoing maintenance, and the ability to look in and address where they failed to operate. So we had the police power, we used that, we put that in place. Again, as I alluded to in the slide. We then took some of those conditions out of the ordinance from the police power that we had, and we put that in the first grant, 50 years ago. It has not gone anywhere. Now, the representative, the attorney, went all the way through the Constitution to find that sort of information about our constitutional rights and due process. That same sort of effort could have been used and expended to look at the original grant and found the conditions by which this operation was established. Yet instead, they spent their time, effort, and resources looking at constitutional constraints that the city had. It wasn't necessary. And as you heard her in her last statement, she's not about trying to comply with the conditions. She just wants to reassure that we are able to extract an energy resource from this community, not interested in complying with the conditions, not interested in the integrity of those conditions. Again, those conditions were put in the original grant. They were restated, part of them, in Plan Approval 1. They were restated in part in Plan Approval 2. The conditions were restated in Plan Approval 3. This is a very fine legal firm, one of the best in the city. One of the best in the city. They would not be hired by this oil drilling operation if they're not one of the best. So they knew where to look to find the operating regulations for this oil drilling site. They knew exactly where to go. They've been working with the city of Los Angeles for many years. They knew exactly where to find our files. They knew exactly where to go. So when Sentinel Peak brought them on as representative They brought on an experienced group of people who know exactly where to go, constitutional-wise, municipal code-wise, and they knew exactly where to go in terms of our ZA case file. This is no mystery to them. They've always known it. What is a mystery is why there is a continual effort to sidestep their lack of integrity or the operator's lack of integrity in complying with these conditions. So what I'm asking from this body is to uphold this decision of the zoning administrative office to insist that these operators look again back to these conditions. Again, these are not new conditions for the most part. A restatement of a bunch of conditions that we've collected and put them in one place. And sure, we've added some, but it's only because they're contemporary conditions for operators nowadays. They're not overbearing. We just ask that you uphold our decision so they can go back, take that set of conditions, and then start showing compliance with those conditions. This is nothing new. This is basically saying, look, let's get caught up. Let's try to mend the lack of integrity that's been around the operating of this site. And if we can try to bring that lack of integrity back into place, I think we will not have the complaints that you hear today. I think you will not have to hear from these operators, you would not hear from the zoning administrative office. Again, it gets back to the integrity of this whole thing, and if we could just get back to that, I think we'd be fine. Thank you.
Thank you. Any questions from Ms. Irving? Thank you. Public testimony is now closed, and the commission will deliberate. Commissioners, your opinions?
This is Commissioner Orozco. Generally, based on the collective testimony that we've heard, both from staff and community, I think that based on the staff report, I have no question in terms of the city's authority to restate and amend or bring up to date the various conditions. I think it was clear, even despite the questions of police authority or the municipal court, the initial approval of the operations for the site had a clear reservation of the right to add further conditions as necessary. So there's no question in my mind in terms of the city's authority and ability to bring forth these additional conditions. And in terms of the community testimony that has been presented, I think that addresses one of the other points that was raised in terms of whether there was sufficient findings to substantiate the concerns that have been raised. And I think we've heard from a number of different people with direct personal knowledge and direct experience about odors and noise emanating from the site. And so collectively, I think the other point that really resonates with me is just the sheer fact that the conditions merely reflect conditions and upgrades that were long approved for other similar facilities throughout the county of Los Angeles. So I really, I don't see anything objectionable in any of the conditions that have been presented to us.
Commissioner Gail Willis, due to the environmental concerns of the community in reference to the toxins and chemicals that exist from this site, I do adhere to the city's decision as well.
Commissioner Antoinette Anderson, I do adhere to the city's conditions as well, especially after Christine Haley stood up in front of all of us and said that the firm was not aware of any permits or compliance that you so stated today regarding the environmental health and safety.
This is Commissioner Stern. In terms of the appeal, I would like to echo Commissioner Orozco's sentiment that it does seem that the zoning administrator is well within the scope of his responsibility in terms of looking at the conditions and
revising conditions as needed. What I'm hearing is that this is a 50-year-old approval, that some of these conditions have not been adhered to, and that the necessity of bringing these conditions into the year of 2018 are not only important but vital to the integrity of the work that's being done, and to create an integrity in the whole community, so that both residents and the company is working together and has a foundation that is appropriate in this day and age.
Commissioner Bates. I think the community here speaking was very telling and impactful on me, and I think Ms. Haley, we all can appreciate the importance of oil and gas. I'm sure everyone in here would agree to that, but I don't think it should be at the expense of residents near a site such as this. I think there was substantial evidence supporting the zoning administrator's decision that these conditions are necessary to protect and preserve the health and welfare of those residents in the area. So because of that, I move to deny the appeal in full, sustain the zoning administrator's decision to require corrective conditions, and determine that the action is categorically exempt pursuant to CEQA guidelines section 15303 subsection E, and city CEQA guidelines article 3 section 1, class 1, category 6, and class 21, category 2.
Commissioner Willis, I second the motion.
Ernesto Velasquez, City Attorney's Office. I believe also the motion would be to adopt the findings of the zoning administrator, just to make sure you include that in your motion.
Yes, to adopt the findings and deny as I just stated.
Etta Armstrong, CEA. We have a first and second motion on the floor. Commissioner Bates, how do you vote?
Yes.
Commissioner Willis, how do you vote?
Yes.
Commissioner Anderson, how do you vote?
Yes.
Commissioner Orozco, how do you vote?
Yes.
Commissioner Stern, how do you vote?
Yes.
Motion passed.
Time now is 6:49. The meeting is adjourned.